OK，11点了 ，It's time。
好，开始吧。
好了。Hello everyone. Welcome to join our webinar issues on commercial dispute settlement in China under the outbreak of COVID-19. My name is Liu Feiyu, and this is my colleague Sarah de France. We work for CCI France China. This webinar is composed by two parts. The first part is a presentation of the speaker. It will last about 1 hour. And the second part is Q&A. It will last about 15 minutes. If you have any question, you can write them down anytime along the presentation or during the Q&A part. There is a chat. You can write them down here. And we will collect the questions that you ask and transfer it to our speaker. And now I have the pleasure to introduce you our speaker, Mr. Lin Wei. Mr. Lin Wei is arbitrator, doctor of laws. Dr. Lin is currently a part-time professor at Second University of Paris, EM Lyon Business School, Schema Business School, East China University of Political Science and Law, and East China Normal University. Dr. Lin is expert in commercial dispute settlement, mergers and acquisitions, and other legal fields. Now let's welcome our speaker, Dr. Lin.
Okay, thank you, Fei. Thanks for your kind invitation and the kind invitation of CCI. Today it's my pleasure to give a presentation about the dispute resolution under the coronavirus. As you may know, that I still remember that it was two months ago that it was the beginning of the coronavirus. And at the beginning, we think that it is only in China, and if we block all the frontiers, that things will be much better. But nowadays, we think that it is not only a Chinese problem, but also a global problem. So the impact of the execution or performance of the international contracts will be the first very important issues for everybody, particularly for international businessmen. So first, I think that I will have a brief descriptions on the impacts or influence of coronavirus regarding the execution of international contracts. Here, I just have some list of some important international contracts. For example, we start from the international trade contract, which is the most common for international business. As you know, that in general, that we for international business, we know that we understand that they have several stages, right? So for each stages that they might have, if they have some impact from the coronavirus, this kind of the impact will absolutely make influence on the execution of the international contract, right? So for the international business contract, we think that the transportation and also the declaration of the customs are very important. So under the coronavirus, from the beginning till now, we understand that not only in China, but also many countries issues many rules and restrictions on the shipments. For example, some ports prohibited the ships at the beginning from China, but now maybe from the other countries, which is deemed as the coronavirus impact region. For example, Italy, or for example that Spain, or even now the UK. So all of these difficulties for the international transportation will cause a delay of the shipment and of course will cause the seller or the purchaser under different scenario to book their shipment a couple of days in front before. For example, in China, we highly recommend the Chinese sellers, if they want to find a forwarding company or a ship company, they need to do it at least 15 days before their shipment. In this way, we can very well discover which port and which place that the ship will not go, and all the local authorities will have specific expectation or some specific rules of restriction, etc. That is the first influence of the shipment and the delivery. Of course, this will make the price rising. For example, not only ship by sea, but also the ship by air is also a very important method. But during this period of time, that the air transportation has also been heavily restricted. Here I have a map for different methods of the transportation. For example, the ocean shipping and also the air transportation. And also we understand that here we come back to the shipping. If you want, we know that if a port, be deemed as a safe port, it should have certain conditions. But under coronavirus scenario, certain ports may deem as unsafe. So for ship transportation, that the time charter, it will have less impact on it. But for a voyage charter, if the parties reach an agreement at that moment, you have already know that these ports has already been influenced by the coronavirus, and the local authorities has already issued some restrictions on the shipments. That will be very hard for the shipper to claim that is port we need to unsafe port that we have to change, etc. So for time charter party, there will be less risk, but for a voyage charter, it will be a higher risk. That is an example for the ocean shipping. And then for the air transportation, as I mentioned just now, we understand that in relation with China, Chinese air cargo transportation market, that mainly we have the belly cargo and the full cargo. Because of the coronavirus, lots of the flights in China, not only in China now, but also globally, are canceled. So that the carrying capacity of the belly cargo is greatly weakened. I think that's also the air freight is increased because of such cancellation of the flights. I mentioned here a certain figure. That means that global air cargo volume fell by 9% in February. Since comparing to the 2019. For the passenger flows, I think that will also have great impact on the international business as well, because lots of the flights canceled. So and also, for example, in China, I think that nowadays it's fine, but till now we still have Wuhan city under blockage, right? And the other area is opened, but under certain conditions. The new increase of the figures for the coronavirus positive people are still very high control on the air flight from abroad. So all of these will have great impact on the movement of the people. So relatively, in certain way, it will have influence on the international business movement. That is air transportation. And then let's come to another sector which will have absolutely have some kind of the heavy impact from this coronavirus. That is the international supply chain. Because as you know, that China now is the leading manufacturing country in the world. So in the supply chain, manufacturers in China play a very important role inside. I will give you an example about the automobile industry later. For this kind of the business, during the past 2 months, as we understand that many of the Chinese factories are closed down, so they cannot resume to work. So there's in such circumstance, that's the productions and provisions of the products for the purpose of international supply chain will be heavily have influence on. So, and also not only for the production for the Chinese production of the products, but also the supply for Chinese production of factories are heavily impacted. For example, we need to import also the raw materials, right, from abroad. In this way, if as I mentioned just now, if we have strong impact on the shipments or on the custom declaration side, the additional inspections will be conducted. So all of this process of international supply chain should be slowed down, and certain products even you cannot find immediately a component to replace. For example, I hear mentions the automobile industry, because this industry is a typical capital and technology intensive industry, right? And due to its high technology content and the long industry trend, I think that the globalization characters has such kind of the play such very important role inside. So the automobile industry's supply chain is heavily affected by the epidemic situation. And because we have some clients in Wuhan, they are the manufacturers of the automobile components. And during these 2 months, of course, they have to shut down the production chain. And also they have to find some components to replace for their supplying contracts. But one issue for the automobile industry is that since 2011, because of the earthquake in Japan at that time, as we know that Japan is also a very important automobile manufacturing country, and many important components are manufactured in Japan. So the people take the lessons from the earthquake accident in 2011 and put many clauses inside the supply chain contract to have a full image or full descriptions of the certain circumstance that will be deemed as a force majeure issue. And under this force majeure, that's the purchaser of the automobile components, they are free if in 1 month that this kind of situation cannot be changed, they are free. For example, they are free to find another manufacturing company or components manufacturer to replace its automobile components. So nowadays that in the international supply chain contracts, they have a very full and serious clause in relation with the force majeure. So during this coronavirus moment, that many automobile companies in China, they are using these clauses to avoid any serious conflict. So I think that this kind of the clauses are very useful, and in certain way that I think that we can adopt it in other international contracts for reference to avoid the same disputes raised out in future. So that is the automobile industry impact by their epidemic situation now. And then for this industry as well, some small and medium-sized domestic components and parts suppliers are relatively, as I say, that's a serious impact against the risk. Of course, comparing to the other automobile OEM companies. So that is for the international supply chain industry. And then I think that another very important business will be affected by the coronavirus. That is the international project construction. Hereby, I think that is mainly in relation with the Chinese investments abroad. Because as you know that since the decades of 20 years ago, that Chinese investments are increasing very fast in Africa and also in Latin American countries. So for all of these projects, the Chinese owner, the Chinese constructor, they prefer to use many workers from China. But under this coronavirus scenario, the working permits or the working visa has been stopped by many countries. And also even in China, that slowed down, the immigration office slowed down to deliver the passports or some important international traveling documents. So in this way, the sending of the workers from China to abroad for project constructions has been seriously affected. So that is another very important issues for international project construction slowing down for the moment. Nowadays, if we see the figures of the illness under this coronavirus, we found out that in Africa and also in South America, we still have not so many figures, but we cannot make a conclusion now. We cannot foresee that in near future they will not have any increase in Africa and in South America. So in this way, that if it will be, there will be another problems for Chinese projects over there. Because as per our experience during a period of time from 2014 to 2016, when there have some serious epidemic situation in Africa, many, for example, in Libya, that many international projects rounded by Chinese companies has been shut down because of the local illness situation, epidemic situation. So I think that that is another potential risk for Chinese international projects construction business as well. And also, I mentioned here on the bottom line, that is the fourth point, the domestic manufacturers are unable to resume the work on time, right? So there will result in delay in supply of the equipment to produce or to transport to the further projects constructions in Africa or in Latin America, and also the shipments will be delayed. So all of these elements will cause comprehensive delays of the international construction projects overseas for Chinese entrepreneurs, for Chinese entrepreneur. Another very important impact, we think that it is the entertainment contracts execution. As we know, that other cinemas and also entertainment places are closed down since 2 months ago in China. But nowadays, that's from beginning of March, that many entertainment places, I think all of the entertainment places and the cinemas are shut down in Europe, and also nowadays in the United States. So the international entertainment contracts or international film or cinema import or exportation business will have a big impact on. So that is another international business contracts that we should take into consideration, that in the near future they will have many disputes rising from. And also how to I indicate here another issue is about the for example, the premise leasing, right? The office buildings lease agreement, how to handle it. Since 2 months, that the people, is very hard to move here and there, and also the Chinese government encourage people to stay at home for a remote work from house, from home. So all the business is slowing down, but the leasing fees, the rent fees, we need to pay still. So nowadays in China, many places that the leaser raise some applications and even some manifest against the owner of the building for reducing the leasing fees during these moments. So all of these will cause some disputes out. And also for the big cities like Beijing, Shanghai, Guangzhou, or Shenzhen, we have many owners are foreign companies, right? The international companies. So that is also the international commercial contracts. So international commercial leasing contracts will be heavily impacted. So that is the example I have mentioned, and also how to if we bear some damages under this scenario, how can we, and also we cannot execute our obligations under the international contracts which I mentioned before. How can we allege our rights and avoid the future responsibilities? So the force majeure or the other similar principles like change of circumstance are very important at this moment. And since the beginning of the epidemic, I think that many lawyers, arbitrators, or judges focus a lot on the force majeure issues. So let's come back to this important issue to see that what is the force majeure and the change of circumstance principle under Chinese law. I think that's first, I would like to say that force majeure is a typical and the traditional principle under the continental law system countries, under continental law system. As you may know, that in this world we have two main very important legal systems. One is the continental law systems, right? The other is the common law systems. The France, Germans, and continental countries, majority or almost of them are the continental law system countries. For the UK and also US, and also the previous colonialized regions for United Kingdoms, they are also under the common law system. So the force majeure is a traditional principle under continental law systems. So China is a continental law system country. So the force majeure has been stipulated in the contract law and the other important civil rules and the regulations. The most we can see that here that it mentions party who is unable to performance a contract due to force majeure is exempt from liability in part or in whole in light of the impact of the event of force majeure, except otherwise provided by law. When an event of force majeure occurs after the party's delay in performance, it is not exempted from such liability. For purpose of this law, force majeure means any objective circumstance which are unforeseeable, unavoidable, and insurmountable. So these three elements are very important to consider whether these certain circumstances are force majeure or not. I can say that because you know that in 2003, China we have the same situation like today. We call it SARS. So we can make a reference to the court reactions at that moment. The SARS was deemed as a force majeure at that time. And also, since 2 months ago, that many I will tell you later that many local courts in China say and consider that this coronavirus situations is the same as SARS. So at the beginning, nobody will foresee it, and also even now we cannot avoid it, right? And if the business has been heavily impacted for many companies and many industries, we cannot overcome it. So we say it's insurmountable, right? So I can say that under Chinese law, that's the coronavirus epidemic could be deemed as force majeure. Now, another principle is the, but not all the effect or the impact by this epidemic situation can be deemed as force majeure. Only because I think that's from the court's point of view that they will take it into serious consideration and to avoid the abuse of usage of force majeure. So, but for certain contracts, if they cannot use their force majeure, how can we do? Under Chinese law, we have another principle which is also very important. We call it change of circumstance. This principle is coming from the principle of fairness. What does it mean? Let's see it on the right side. Where any significant change in the objective environment or circumstance has taken place after the conclusion of a contract, which will not have been foreseen by the relevant parties at the time of conclusion of the contract, and does not belong to any force majeure cause. Here you see, does not belong to any force majeure cause, but this kind of the circumstance render the continual performance of the contracts manifestly unfair to the relevant party, or make it impossible to realize the goal of the contract. At this time, the Chinese courts will confirm that this kind of the contract can be modified or terminated in accordance with the principle of fairness. That is the we can say also in accordance with the principle of change of circumstance. And then the concerning party could apply for the court for modifying and terminating the contract. So in brief, that's we can see that if in some circumstance we cannot allege this circumstance as force majeure. For example, I give you an example. I think it will be easier to understand. Let's come to a case in 2003. At that time, during the SARS time, a ship entertainment ship leasing contract dispute was raising out. Because we know that from the February to April, it is the moment of the SARS, right? But these ship leasing contracts has concluded for 1 year from January to December. So the court think that from the February to April, we can say that is a force majeure. But from the May to the December, the SARS has finished. So we cannot say that is still a force majeure because you understand fully that this situation has happened. You should take the best as you can to reduce the cost and to run your entertainment ship business. So the leaser of the ship, you should make the best way to run your business, and then you should pay your leasing, your rent fees of the entertainment ship. You cannot say because of these 3 months SARS, I will terminate the contract. I will not pay the whole year's leasing fees. It is unfair. It is unfair. Not only it is unfair for the ship owner in this way. So I think that is adversary example. But we can see that the court is very prudential and serious to confirm that certain period of time or certain circumstance could be deemed as force majeure. And except that if we want to use any principle to exempt our performance of the contract or to avoid the responsibilities of the delay in execution of the contract, I think that the change of circumstance can be used as well. But it depends case by case. Each case has different facts, so we need to analyze it case by case. But in principle, we understand that the force majeure is accepted for coronavirus in China. If you cannot use force majeure, you can use the principle of change of circumstance under PRC law. Okay, so that is the Chinese law. And then we come to the other countries because I think that's the global impact of epidemic become more and more serious and heavily. So we need to see the other important countries' principle or a similar principle that's force majeure. I give 3 examples here. One is the UK, the other is US, the third is the force majeure under French law. Just a brief introduction because of the timing. So the first, I think that's under the UK law, they have a similar principle. We call it a frustration of the contract. I think that's because of this circumstance that for their parties, they will feel frustrated if they still execute full obligation under the contract. So we can say that is a frustration of the contract, and the responsibilities under the contract for all the parties can be exempted under if the court can consider this situation as a frustration of contract. So what is the important elements or precondition for this principle? I have 4 paragraphs here for your reference. in accordance with the UK case law of precedents. Firstly, there has to be a radical change in circumstance that cause the performance of the contract to become unjust and unreasonable. Okay, so I think that that is a change in circumstance and make the execution of the contracts become unjust and unreasonable. I think that is also very similar to unfair in my personal point of view. So if this change of the circumstance make the execution of the contract become unfair, I think that it is a very important precondition. The second one is that the consequence for this frustration of contract would be termination of the contract. And third point, this kind of termination is terminate automatically, and neither party, no party, should bear any responsibility to each other. Okay, so that is the legal consequence if the court acknowledged or recognized that this coronavirus situation, this frustration of contracts, all the contracts will be automatically terminated. Be careful. So that is in this, because of this serious consequence, I think that the judges from the UK courts are also very prudential and carefully to consider whether every event or every facts happens during the epidemic, during the coronavirus, could be deemed as a frustration of contracts. So that will come back to the principle of case-by-case study. So we cannot make an absolute conclusion that here that epidemic situation of coronavirus could be 100% deemed as frustration of contracts. Okay. And also the fourth elements precondition, very important, is that the reason why the contract is frustrated should not be the act or choice of the frustrated party to avoid the performance of the contract. Okay, so that means that this kind of the circumstance cannot be a party's intentional act. Okay, that should be in another way, like the Chinese law say, that is objective change of the objective environment or the objective circumstance. So that means that it is not the parties who intentionally make these things happen. And I think that in an extreme case or example, if in UK, for example, a person who want to close down his factory and then let the people to be risky or to be dangerous, affected by their the coronavirus, I think that he cannot use the principle of frustration of contracts to say that all his, for example, production contracts should be terminated automatically because it's intentionally bad act or action by him who make his factory come into difficulties, who make his company cannot execute the contract. So that is a comprehensive or a complicated case. I think that's case study. We should depend on all the evidence and the proofs in relation with to see whether this condition can be deemed as frustration of contract or not. Okay. And also on the last line, we see that it is unexpected external circumstance. Okay, external circumstance. There's nothing to do with all the parties of the contract, and also it's unexpected, like the word unforeseeable, right? So we can see that all of these principles are very similar. So let's come back to the another principle, similar principle under U.S. law. That is, we call it impracticability principle. Okay, that is the doctrine under U.S. law. But for the U.S. court, usually require the affected party to prove the below situation. First, this special occurrence made it extremely expensive or difficult to perform the contract. I think that here I highlight the extremely expensive or difficult. I think we can come back also to the principle under Chinese law and also under UK law, right? Just like it principle to consider whether it's reasonable, whether it's fair to the parties to execute the contract. And the second is that the parties initially enter into a contract under a basic assumption that certain special circumstance will not occur or will not happen, right? So that means that at the beginning, when you enter into a contract, you will not foresee that this kind of the circumstance will happen, right? And there is no contractual provisions on bearing of risk arising from such particular circumstance. That means that because of you did not foresee these things happened, or these things is unexpected, so you will not have some special contractual stipulations or provisions in the agreement, right? If you have this kind of the agreement, that means that you have foresee it, you have expected that this kind of circumstance will happen. So in this way, you will not use or you will not allege this doctrine of impracticability. Okay. The third element, very important, is that these special circumstance happens actually make difficult the performance of the contract, or actually that make this execution of the contracts become difficult to overcome the difficulties. For that is, I think that is very similar to the third principle under the force majeure. That is hard to overcome this circumstance. I think it is the situation now, not only in China but also globally, in Europe, in Italy, in Spain, in US, in Canada, in many countries. It's very hard and difficult to overcome this from the present technology of the other hospital technologies or the sanitary technologies. Okay, so that is the three very important elements that should be considered whether it consists or not doctrine of impracticability principle under U.S. law. Under French law, I think that French law has is the continental law system. So no doubt that in the Code Civil, if there is no force majeure in the contract, in the Code Civil, there is a relevant article to 1218 to describe which circumstance can be deemed as force majeure. And we can see here that is beyond the party's control, and also could not be reasonably foreseen, and also could not be avoided. The three main principle, right here, unforeseeable, out of control, and hard to overcome, right? So that is the principle under French law. Because the timing, I will not spend too much time on it. I think that's another issue very important I would like to mention is what is the Chinese court response to this coronavirus. For the dispute resolution, we know that internationally we have several methods. The negotiation and mediation is the first way before go into the arbitration or litigation, right? That is the dispute resolutions methods traditionally. And in China, the court hierarchy, we need to have a brief idea about it. That is, in China, it's not like in France, for example. In France, we have three instances for case. The first instance and second instance, we call it, we go to the cour d'appel, for example, right? That is a peer proceeding. And then the third, that would be the cour de cassation in French. We say that is the Supreme Court in France to make the final decision. We call it maybe we will not call it the third instance, because the French Supreme Court only judge on legal grounds, not on the facts. Okay, let's come back to China. China, we have two instances for case. That means that we can have the first instance, and then the second is the final judgment. Okay, and according to the different amount of the disputes, and also according to different characters of the disputes raised out, it will be different courts for the first instance. Okay, for example, but normally we have four hierarchy level of the Chinese court. The highest is the Supreme Court, and its circuit courts in different cities. The second level is the higher people's court, normally at the provincial level. Okay, at the municipality directly under the central government's administration, like Beijing, Shanghai, and Chongqing, Tianjin. These four cities, they have the higher people's court. And then the third level is the intermediate people's court. The fourth is the basic level. So if the first instance is in the basic level, the second instance should be in the intermediate people's court, and then intermediate people's court will be the final judgment. Okay, if the higher people's court is the first instance, the second instance should go to the Supreme Court of China. Okay, then the Supreme Court's judgment is the final. For the arbitration commissions, here just indicates the main arbitration centers or commissions who are dealing mostly the international disputes. The first one is the most famous, CTEC. CTEC, the headquarters is in Beijing, and in all over China, they have, I think that's a little bit less than 20, around 20 sub-commissions. The second one is very important, is the Beijing Arbitration Commission. The third one for international business is Shanghai International Arbitration Center. And the other three, that is very important international arbitration centers for the Chinese relative international business. One is the HKIC in Hong Kong, Hong Kong International Arbitration Center. And then it is the ICC court. We are familiar with it. The headquarters is in Paris. The third one is for Stockholm Chamber of Commerce. It's a very traditional arbitration institution for Chinese companies to choose. And also the others, like Singapore International Arbitration Center, I did not mention here, but also that is also very important for arbitration practice. During the corona or epidemic situation, that's online litigation and arbitration becomes more and more popular. And also mediation during the litigation and arbitration become more and more important, because they encourage no-touch case filing, and no-touch trial online, and no-touch delivery of the documents in a remote way. So all of these are available, for example, on APP. For the case filing for many courts and also the arbitration commissions in China nowadays. I say here that more than 3,500 courts have joined China mobile micro courts to support online litigation activities. Even today, that we know that the figures in China, in mainland China, become much better than 2 months ago, much better. And the new cases mostly for the big cities are coming from abroad, but we still be the people, and here we are very serious and prudential to keep it, avoid a second wave of the spreading of coronavirus in China. So that is the reason till today that online case filing or trial very popular, and I think that not only today, but also in the near future, we can see that in the next 3 or 6 months, it is still the trends to make all the case filed and trialed and documents delivered in a remote way online. I have give an example here that during this epidemic time that many local courts, as I mentioned, issued many guidelines to make the people useful reference. The first is the definition of the force majeure. As I say that in principle that all the Chinese courts guidelines recognize that the coronavirus can be deemed as force majeure, but they have some conditions to meet. I give some example here. First, the parties did not foresee, right? That is unforeseeable, which I mentioned just now. The second one is that the government where the party is located really take serious epidemic prevention and control measures. I think during the past 2 months, almost all the Chinese local government take the measures now. The third one is that this kind of the measures should take place after the contract is concluded. That is a very important timing. This timing is case by case and place by place. That means that different cities and different places, they may have the different standard because the local government issued the prevention control measures at different time, and also they release it at different time. Okay, and then the fourth one is that we need to prove the causal relationship between the epidemic and also the implementation of epidemic prevention and control measures, which it cause difficulties of the execution of the contracts. The causal relationship should be between these kind of the measures and also the improper execution of the contracts. Okay, they should have consequence, impact between these two. The last one is that these kind of the causes cannot be avoided, overcome, just as I mentioned. And the second point by the local courts is that they make some exclusion of the force majeure. Okay, if you can see or you should know, you can know and should know it's not enforceable. You cannot use the force majeure. Okay, if no causal relationship, you cannot use force majeure. And if it is, you can overcome it or you can avoid the happens or the losses under your contract, or it's possible for you to change another way to execute the contract. You should try your best to use another way to execute the contract instead of saying that, okay, because of the coronavirus epidemic, I cannot performance my contract. It is not so easy. Okay, you should make your full efforts and try your best to reduce and decrease the losses and damages raising from the impact of epidemic situation. So that is the local courts guidelines. I would like to find the last point I would like to mention is the international commercial mediation. I propose that it would be the best solution for the commercial disputes under outbreak of coronavirus, because I think that mediation nowadays become more and more popular, and also is less costly, to be honest, comparing to the litigation or even the arbitration. And also during this period of time, I have contact with different clients from different industry. They always, majority, almost of them told me that the business relationship very important, and we would like to build up a long-term relationship between each other, among each other. So at least the coronavirus will pass away in a very near future, but our business will take much longer than that. So we will choose not to go to the court or arbitration commission during this moment, but try to find a alternative solution, try to find a amicable way to resolve it together. So I'm personally also very positive and for this point, and I believe that the business, if the coronavirus did not affect totally the goal of the contract, I think it's better to execute a performance contract at least partially. That is the best way. Sorry, I think I lose the line just now. It's okay?
Okay, now it's okay. Now it's okay.
Now it's okay, okay?
Yes.
You can see the full screen of the... It's okay?
Now it's okay, but we can't see your PowerPoint.
You cannot see my PowerPoint.
Yeah. So please share your screen.
Okay.
Oh, now it's okay.
Okay. So I think that's the advantages. I continue the advantages of the mediation. We should keep in mind that the judge's responsibility for court is to interpret and rule on matters of law, and but the mediator's responsibility is to assist the parties in settling their disputes and be fair and equitable to all parties. Okay, the purpose of the mediation is totally different from litigation and arbitration, and also because it's authority, convenience, flexibility, and also maneuverability, and the wide application. I think that international commercial mediation systems has become the most practical and efficient way to resolve disputes, particularly under the global impact of coronavirus. Okay, I think that I have also some minutes to show you about the new international mediation convention. We call it Singapore Convention. It is a very good news that on the 12th March, the last signature states have signed this convention. So this convention, I think, come into effect this month. And according to this convention, all of the settlements, amicable settlement agreements made under the mediation for the conventional countries can be legally enforced, like a judgment or arbitral award. So that is a very good news for international commercial mediations. So and also for mediations now in China, that's the CCPIT in Beijing, and also many local institutions. They have online mediation, like in Shanghai, the Shanghai Commercial Mediation Center, in Shenzhen, the Shenzhen Benchmark International Mediation Center. They are all the very good have very good experience on international mediations, and also they have very good international mediator to assist the parties. So I think that if you have disputes, I think the first way at this coronavirus situation under this scenario is to contact online mediation to resolve your disputes. Okay, that's all. Thank you, Yifei.
Okay, now it's a Q&A part. Hello,
Yeah.
Dr. Lin. Okay,
Yes,
so
yes, I'm waiting for some questions.
yes, and Dr. Lin would like to take a break. He will come back to us in several minutes. So during this time, you can write down your question in the chat. Okay? Okay, now we received one question. Dr. Lin, can you hear us?
Yes, yes.
Okay, we have received an inquiry from a trading company. What can we do if the supplier cannot deliver the products as scheduled? We paid some deposit to the supplier. Could we cancel the order and ask them to refund?
Well, I think that's it's better firstly to know the reason why they cannot supply the product, right? I think that's the supplier or the seller, they should give you explanation. For example, if they say that is the coronavirus has that certain effects on the production, they cannot provide, right? And then you should consider from your side that as a purchaser, whether you can wait or not, the delay of the production. If you cannot wait, and also it is affected by the coronavirus situation, I think both of you should negotiate and use the termination of the contracts as the remedy in this way. And so that is depend on firstly the negotiation way, and I don't know exactly what the suppliers the reason why they cannot. So it's very important.
This is because of coronavirus.
Because of the coronavirus. Okay, so if you cannot wait, I think it's better to propose to cancel the contract and get back your money.
Okay. Okay, thanks. And arbitration is inapplicable. Is it theoretically if the result goes against the interests of our company? Hello, Dr. Lin.
Yes, what's the question?
And arbitration is inapplicable. Is it theoretically if the result goes against the interests of our company?
The arbitration. The question.
仲裁是不可上诉的。
Okay, so of course, the arbitration is a final decision between the parties. So you should be careful. If you choose the arbitration, that is the final binding arbitration award between the parties. So you need to respect it, and you need to follow the decision made by the arbitrators, and you waive your right to go to the court.
Okay. Now we are waiting for the second question.
Yeah. So we come back to the question just now. I think that the arbitration, we say that it's always less costly, but it depends on case as well. If it's a very big international arbitration, it also will take a long time, all the same time as in the court proceeding. But the court, as per our experience, for the court hearing, you can have first and second instance. You can have the right to appear. But for the arbitration, be careful. It is just one stop. Okay, you cannot raise any appeal against the arbitral award, except that this kind of the arbitration has kind of the default or some problems in the arbitral proceeding. That is always the reason that the party can raise against arbitral awards in front of the court for saying that, for example, the arbitral did not respect the proceeding. He did not get the notice of arbitration to go to the arbitral hearing, or for example, that he did not. He has, for example, appointed the arbitrator, but the arbitral tribunal did not accept it for some unlawful reasons, for example. So that is the difference, advantages and the disadvantages between litigation and arbitration. Yes.
Okay. So, dear participants, do you have some other questions?
Yeah, if you have further questions, you can also add me on WeChat or contact me with my email address. I showed it on my slide.
Oh, okay, I see that nobody has some questions now. So thanks, a big thanks to Dr. Lin for your instructive presentation, and thank you all for your participation to our webinar. Thank you very much.
Thank you, Yifei. Thank you very much, CCI. Thank you for every participant's time. Okay, thank you very much.
Okay, thank you.
Okay, bye-bye.
Bye-bye.